Good morning, I'm Dan DeRose with 19 News Now, coming to you from our digital desk here. You're looking at just a teenager, that is Darrell Travis. He is the individual who has been convicted of a string of carjackings in Little Italy on Cleveland's east side. There were at least 3 that he is claiming responsibility for. He's pleaded guilty to 5 counts of aggravated robbery, 1 count of felony assault, 1 count of having a weapon under disability, that is a felon in possession of a firearm, and 1 count of carrying a concealed weapon. Listening in court, nothing's been said yet. They're waiting on his defense attorney. You might remember this this string of carjackings. It really put that neighborhood December of 2021. So we're kind of in the pandemic. And then to have 3 carjackings at the hand of a teenager. In one case, there were 4 women who were in a car and he used a gun to get them out of that car. Then there was a man in University Heights who was carjacked at the hands of Travis. And then in the most serious carjacking, he shot a woman twice in the stomach before stealing her car. And again, all of these crimes were happening when he was just 14 years old, meaning he is approximately 16 now. He has been tried as an adult. He was supposed to be sentenced last month, but he failed to show up for his sentencing. Since he was arrested as a juvenile, he was put on GPS monitoring, and that's how he was allowed to come and go. But then, and the arrest process for this was not easy. He was identified by the U.S. Marshals Service. An arrest warrant was issued for this teenager then after he missed his scheduled April 19th sentencing. And we know that he had cut off his ankle bracelet and fled, took off before his sentencing in April. So we'll have to see if the judge, holds him to account for that, as well as the 3 carjackings that took place in this. We've interviewed a handful of times some of the victims in these cases, and I believe there are some in the court that will be allowed to talk to the judge before he is sentenced, give their victim impact statement on how this has impacted them. It's really interesting that they're having this, Darrell Travis stand there at the podium. We're listening in. Nothing is going on in court. Normally he is seated at the defense table, so not exactly sure why he's at the podium at this point. We know his defense attorney was a little bit delayed in getting there. The judge was speaking with one of the other co-counsel, saying that they were waiting on an elevator to get up. And there, I believe, there's the state. Those are the prosecutors coming back. There are his attorneys, and the judge is in court. And it looks like the judge may have some instructions about whether or not we can show this individual.
Right. We've been live.
And the problem is he's already in the courtroom and we've been showing him, so if that's the case here, we'll have to just trying to listen in here to be able to.
Take it off, turn it off, point your camera someplace else. Got it? Or do you want to be out of the room altogether?
No, you're fine. I just want you to know we've been live streaming with some of that station showing this case.
Okay, so now stop. Let them know. So are you still streaming right now? Okay. I want you to turn the cameras now so that it's not showing his face. Do that now. Thank you.
Yeah, that's what we're doing.
Okay.
Okay, so the judge has given our staff some instructions on what can and cannot be shown. And I did hear our photographer explain to the judge that we had already been live streaming. She understood.
Counsel, come sidebar real fast, please.
And now the judge needs a sidebar. This is an interesting case because normally when you have a juvenile involved, but he's being tried as an adult or was charged as an adult, he then pleaded guilty as an adult to numerous counts, 5 counts of aggravated robbery. But then clearly his attorneys got into the court today, saw that there was a camera, and made the request at the last second to the judge to ask that he not be shown. We normally do not, as a policy, as an organization, we do not show juveniles unless they are being tried as an adult. That was the case here. He had been charged as an adult, and so therefore that's why we were showing. I believe he is probably now 16 years old. He was 14 at the time of these carjackings. And it looks like we're going to get underway.
Counsel, you get the opportunity to review the pre-sentence investigation report.
Yes, Your Honor.
Thank you very much. We are here for the sentencing in case number 674056, State of Ohio versus Darrell Travis. Mr. Travis is present in court this morning along with his counsel. Counsel, would you please state your name for the record?
Good morning, Your Honor. Attorney Lon Cherie Billingsley.
On behalf of the State of Ohio, would you please state your name for the record?
Yasmin Hassan, Assistant Prosecuting Attorney, Brandon Pateo, and Ani Lee Conroy, Your Honor.
All right, thank you very much. Previously, on March 20th, 2023, the defendant pled guilty to the amended count 1, aggravated robbery. That is a felony of the first degree in violation of 2911.01A1 with a 3-year firearm specification attached. The 3-year firearm specification must be served first. It is mandatory time. On the underlying offense, it is anywhere from 3 to 11 years in prison and an indefinite term of up to an additional 5.5 years for a total possible on the amended count 1 of 4 to 20 and a half years. The defendant also pled guilty to the amended count 8, aggravated robbery, a felony of the first degree in violation of 2911.01A1 with a 3-year firearm specification attached. That is a possible penalty of 4 to 14. I'm sorry, that's wrong. The first one was wrong. 7. Okay. 6 years. Okay, all right. Let me just start over because that was wrong. Looking at the possible penalty for the amended count 1. The 3-year firearm spec plus the underlying offense from 3 to 11 years. That makes that a possible 6 to 14 years, and then the 5.5 years of the indefinite term makes that a total of 6 to 19.5 years possible. I think I did that right. As to the amended count 8, 3 years for the gun spec, and then the 3 to 11. So it's a total possible from 6 to 14 years in prison and a fine of up to $20,000. The defendant also pled guilty to the amended count 15, aggravated robbery, a felony of the first degree in violation of 2911.01A1 with a 3-year firearm specification attached. Again, that is looking at a possible 6 years up to 14 years in prison and a fine of up to $20,000. The defendant also pled guilty to the amended count 22, aggravated robbery, a felony of the first degree in violation of 2911.01A1 with a 3-year firearm specification attached. He is looking at anywhere from 6 years in prison up to 14 years in prison and a fine of up to $20,000. The defendant also pled guilty to the amended count 29, aggravated robbery, a felony of the first degree in violation of 2911.01A1 with a 3-year firearm specification attached. He's looking at anywhere from 6 years in prison up to 14 years in prison and a fine of up to $20,000. The defendant also pled guilty to the amended count 34, felonious assault, a felony of the second degree in violation of 2903.11A2. That carries a possible penalty from 2 years in prison up to 8 years in prison and a fine of up to $15,000. The defendant also pled guilty to count 38, having weapons while under disability. That is a felony of the third degree in violation of 2923.13A2. That carries a possible penalty from 9 months in prison up to 36 months in prison and a fine of up to $10,000. And finally, the defendant pled guilty to count 40, tampering with evidence, a felony of the third degree in violation of 2921.12A1. That carries a possible penalty from 9 months in prison up to 36 months in prison and a fine of up to $10,000. The court will note that the parties in this case have recommended to this court that the defendant be sentenced anywhere from 18 years up to 25 years in prison. The court has had the opportunity to review the pre-sentence investigation report that was prepared by the Cuyahoga County Adult Probation Department and has made that report available to counsel. Before imposing sentence, this court will consider the record, the PSI, and any written or oral statements made to the court today as is required by Revised Code Section 2929.19B1. Mr. Travis, we are here to impose sentence in this case. Before I determine what sentence to impose, I will allow you, your attorney, as well as the state of Ohio to address this court. Before we get started, counsel, is there any reason to not go forth at this time?
May it please the court, Your Honor, not at this time.
Then you may proceed.
Thank you, Your Honor. On behalf of Mr. Travis, what is the value of a life? What is the value of being incarcerated? What is the value of being seriously injured? Your Honor, Mr. Travis submits to this court that he is extremely remorseful and apologetic for his actions in each of these cases, Your Honor. And he sincerely apologizes to each of the victims that will come before you today. However, this sentencing is directed to understanding what is the appropriate sentence for Mr. Travis. This court must decide, using the minimum sanctions, what is the sufficient sentence to protect the public, rehabilitate Mr. Travis, and protect the public from future harm. Your Honor, we would submit to you.
For those of you watching on the 19 apps, one of the Cleveland 19 apps, we're going to switch over to our Facebook feed. For those of you watching on Facebook, we will continue.
Mr. Travis is a 15-year-old individual. He stands before this court on crimes that occurred when he was 14 years old. Now, he has been bound over. In the eyes of our system, he is an adult. But in the eyes of his development, as well as in the eyes of the sentencing factors, this court must consider the hallmarks of youth. Your Honor, as stated in the sentencing memorandum, We went through the various factors. The factor that applies to Mr. Travis that makes his conduct more serious is the serious harm that he caused the victims in this case. And as I stated at the outset, he is completely remorseful and apologetic for causing that harm. However, the factors that apply to make his conduct less serious are that there were substantial grounds to mitigate his conduct, as well as the hallmarks of youth. Your Honor, at 14 years old, some people are playing with jacks. At 14 years old, some people are on TikTok. At 14 years old, Mr. Travis was engaging in these crimes. But that doesn't negate the fact that he was still 14 years old. He's still a young man. He's still a child, developing his understanding of right from wrong, developing his understanding of what is too far, what is appropriate, developing his understanding of the law that many adults go through their entire lives without understanding and grasping the ramifications of their actions. And so we're asking the court to understand that Mr. Travis is still grasping the ramifications of his actions, but understand that 18 years in prison will give him time to think about what has transpired, will give him time to work on the things that he wants to accomplish in life, such as a high school diploma, such as gainful employment, such as being an A student. Your Honor, the other factors that this court is to consider is how likely is Mr. Travis's recidivism. As it relates to his recidivism, Your Honor, we've already determined that he's going to prison. We've already decided that. But now we have to decide what prison term, where is that sweet spot of a prison term that will not have Mr. Travis coming out committing more crimes, but will be sufficient enough time for Mr. Travis to reflect and come out as a productive citizen. And I will submit to this court that there are many studies that show that time in prison does not necessarily rehabilitate an individual. But that's where we are in this case, Your Honor. We're at a prison term. And that's what Mr. Travis has agreed to. That's what we're understanding of. But we submit to this court that that agreement to prison, an extensive prison term, should be seen by this court as evidence of Mr. Travis's remorse. In addition to the fact that Mr. Travis confessed. He confessed to these crimes, Your Honor. He accepted responsibility immediately. Now, I know at some point Mr. Travis did cut his GPS monitor, but I would like to remind this court again that Mr. Travis is a child facing double-digit prison time. That is not Mr. Travis's character to run away. It's not his character to commit these violent crimes. Mr. Travis is a wonderful individual. He has a supportive family. He has 23 brothers and sisters, Your Honor. He has a huge support system. And, Your Honor, we will respectfully ask that this court understand that Mr. Travis is not defined by these crimes. Mr. Travis is not defined by these actions that transpired, and he is taking responsibility for. He is going to be defined by what he does moving forward. And if the court would allow, I know Mr. Travis's mom would like to address the court.
Okay, we'll do that at a later time.
Okay.
Thank you, Your Honor.
On behalf of the state of Ohio.
Thank you, Your Honor, and may it please the court, first and foremost, the state would like to thank this honorable court for giving myself and defense counsel several weeks to review the discovery in this matter prior to sentencing on this date. We are here for a series of aggravated robberies that happened primarily in the Little Italy area in the city of Cleveland, the week of Christmas in 2021. The defendant was found.
Counsel,
Yes.
you can take, I'm sorry, you can take your client to the table, because I think there'll be people talking forward. You can just have a seat in the middle there. I'm sorry, you may proceed.
Thank you, Your Honor. Now, prior to this crime spree, the defendant in this matter, Daryl Travis, had a juvenile history of burglary, attempted breaking and entering, and felony theft. And on December 8th, merely 11 days prior to the start of this crime spree, he entered the drug court program in juvenile court, and then failed those obligations and proceeded on this crime spree. And what makes this crime spree different from other cases, Your Honor, is this is not a case where someone's committing a series of carjackings or a series of offenses in one night, which the state submits is also horrible, but this is someone who took time in between each incident before committing the next one. On December 19th, 2021, the first carjacking occurred where the victim's Audi was stolen at gunpoint. 2 days later, on December 21st, 2021, the second victim's Mercedes or car was taken, a Mercedes in this matter. Then 4 days later, on Christmas, the third carjacking happens again in Little Italy. And then on December 26th, the next day, there's a attempted carjacking that happens in University Heights. And then the next day, on December 27th, we have the carjacking of the final victim in this matter, of her Volkswagen, where she was then shot. So while the state submits that there is rightfulness and wrongfulness of actions, the defendant had time between each of these events to consider the rightfulness and wrongfulness of his actions, but continued to go on this crime spree. And then finally, on December 29th, he was arrested in the stolen vehicle with a firearm on his person. In the first carjacking, this full PowerPoint will be linked to State's Exhibit 1 on a disc for this court. This is the carjacking that occurred of the first victim. I'm having some technical support issues, Your Honor. The first carjacking occurs. One moment, Your Honor. I'm going to pull this out. So the first video isn't playing, I apologize. When that car is ultimately recovered, you see that the defendant is signed into the victim's Bluetooth as 156 Lakeshore Row, which is the defendant's Instagram handle that was being monitored by law enforcement officers in this case. Then the second carjacking happens of the second victim in this matter, where they stole her vehicle and also stole multiple payment methods that she had. And then the defendant proceeded to use over in excess of $800 from DoorDash, Uber, eBay, Amazon, Venmo, including one of the items he ordered was a gun laser, which then the victims, after this incident, would have a gun with a laser pointed at their face. And then again, here we have the defendant posting on social media with the gun with the laser during this time frame, and then a payment that he made to himself of $256. Then on December 26th, we have the third carjacking of the victim in Little Italy. The state will play this video. Here you see the defendant approach the victim. A common theme was that the defendant would approach victims as they're sitting alone in their vehicle. And as you can see the laser.
What time of day is this?
This is in the evening, Your Honor. And the state would submit that had this case proceeded to trial, there would have been surveillance footage showing the defendant walking around in the areas of Little Italy, scouring for a victim in this matter, before he came upon this victim sitting alone in her vehicle, which again was a common incident except for the fourth incident. There's the victim getting out of the vehicle. At this point, the defendant actually has trouble starting the vehicle and asks the victim, again with his firearm, how to start the vehicle. And then here's the defendant coming back to the vehicle. And then he takes off. Then we have the fourth carjacking, which is an attempted carjacking of the only male victim in this incident in the series of events. And what's unique about this one is this is the only time that the defendant attempts to rob a male at gunpoint. And in this incident, it's the only time he has other people with him. And thankfully, that victim was okay. He was able to get away in a fleeting second. And then finally, Your Honor, we have the fifth carjacking incident that occurs again in Little Italy, in actually the exact same spot where the victim is shot twice. Here we have the victim getting out of her vehicle. It's in the evening hours again. Here we have the defendant. And the victim's handing over her keys. You can see the laser from the firearm being pointed. He does allow her to take some of her property out of the vehicle before taking the vehicle. And again, the laser is intermittently being flashed as this is happening from the firearm. The defendant then gets in the vehicle. The victim, believing that the firearm, because of the laser, is fake, approaches and asks to take the keys back. And it's at this point that he's going to shoot her right here.
Who was the person that came across the street? That's just another person trying to help.
That was a person that was trying to help, who just happened to be someone walking by.
So he already shot her?
Yes, she's already been shot this time, Your Honor. When he exits the vehicle is when he shoots her. And I can play it again before we.
Yes, please. Okay.
It's when he exits the vehicle that he shoots her. And we have photos of the injuries as well. counsel them back out and then take the property that the victim dropped on the ground. And again, he pleads.
Where was she shot at?
I have photos, Your Honor. She was shot in the abdomen and then again in the leg. Here are photos of some of the victim's injuries. This is on the leg area, inner thigh, outer thigh wound that the victim suffered as a result of the defendant shooting her. And then again, this is the abdomen where she was shot, and then that same leg / pelvic area. Then thereafter, the defendant gets on Instagram and starts talking about being responsible for this shooting that was posted on the Cleveland Remembrance page on Instagram in this matter. Your Honor, the state submits that the defendant in this matter deserves the higher end of the range for multiple reasons. One, he went on a crime spree that escalated in behavior, and it finally, before he ends up shooting someone for no reason. He was in the car at that point. There was absolutely no reason to shoot the victim in this matter. Counsel for the defendant stated in her statements for the defendant that what is the value of a life? Well, the state submits then what is the value of the victim's life in this matter? The defendant had a complete disregard for human life when he shot her. Not once, but twice. And he was already in the vehicle. He could have driven off, he could have left, he chose not to. He risked the life of every single victim when he carjacked them at gunpoint. Counsel for the defendant made statements about him having huge family support, but the state submits that he's had that family support this full time, Your Honor, and he threw that away. He chose to commit these crimes. He did not care about his family. He did not care about the community. He did not care about these victims. And while the state understands that he pled guilty in this matter to an agreed recommended range of 18 to 25, when this court gave him a chance to be out in the community to see how he would do, he threw that chance away. He cut off his monitor, refused to come to court. His own family pled on the news. The Greater Cleveland congregation pled on the news for him to turn himself in, and he didn't do so. He ended up being arrested by law enforcement. So the state submits that he deserves the higher end of the range in this matter. There are multiple victims here present who wish to address this court, and the state may make another brief statement after that. Thank you.
All right, so you can bring up who you want this time. One at a time.
And we do have a victim advocate.
Okay.
as well.
My name is Ross Guidotti, last name Guidotti. I was the victim the day after Christmas. It was a very really traumatic experience for me because for me, this was the first day I was out in Cleveland since moving from New Jersey. I had just moved from New Jersey. The holidays had occurred. Me and my wife were inside. This was literally within a half hour of me venturing into Cleveland to explore. This occurred to me. With that, me and my wife we haven't really explored Cleveland at all, and we've lived here for the last year and a half now. We travel back to our homes in Pittsburgh and spend time there regularly on the weekends because we don't really feel trusted or comfortable going out. At the time, I lived closer to the area where the incident happened. I've since moved further away from that area to just feel like I'm in a more comfortable location. I've made additional steps to protect me and my wife with, home security, defense classes for her, carrying pepper sprays and whatnot, just because this is never something I thought I'd ever be involved in or experience. Have not been to the area where this occurred, just completely avoided it. Even when I only lived 10 minutes away, I would go shop 30 minutes away in a different spot just to not be in this area.
Because you were at Target?
That's correct. I was also in the garage portion of Target. I was in the lower level. I try to avoid parking garages at all costs. Unfortunately, I had to find one today just to be able to park. So I try to stay as close to the exits as possible. I'm not comfortable. I really don't even sit in my car anymore, where I used to sit and do a lot of computer work because I can be remote, and it's just affected really my entire day to day. With that, I mean, I don't want to belittle the point, but it seems like it's very reoccurring. From my knowledge, he was in the juvenile system beforehand, and that was not preventing him from continuing these. I was only one day away from being the person that he pulled the trigger on, and I really believe the only reason I wasn't is because I'm a larger stature than him. Maybe I just got lucky. I don't know. With the plea being 18 to 25, I would think with the minimum possible from your statements earlier, I believe adding up to 32 or 33 years, that anywhere between the 22 to 25 range would be acceptable for this. And that's all I have to say.
Really sorry for your loss. I'm sorry you had to go through that, being new here in Cleveland. But thank you for your statement.
Thank you.
Hi, Your Honor. I'm Ya Gao, last name spelling as G-A-O. Good morning, Your Honor. I would like to thank you for giving me the opportunity to speak, to give a statement of what happened to me on December 21st, 2021. I was robbed at gunpoint by Darrell Travis, who was sitting right there. The first 3 months after that incident was the hardest. I was left with no phone, no car, locked bank account. I was locked out of all my shopping account, as I mentioned earlier, and all various of social account as well. Since I was not able to retrieve all of those because the billing address has been modified, I was not able to know what address was he did modify to, so I was not able to get all of them back. I spent days and weeks with customer service on my phone trying to prove my identity, explaining that again and again how someone else had access to my personal account is because I was robbed at gunpoint. I was so stressed about everything that I just locked myself in my room. I did not go to class. I did not talk to my family, my friends. I cut off all my social networking because I don't want to repeat again and again the worst memory of my life. I was having nightmare each night about the night, everything he said, how he pulled the door, and how he forced me out of my vehicle with a gun, and how he threatened me. Till this day, I still remember every single word he said to me and everything he did. I did not feel safe even at home because I feel like the door of my room is just as easy and fragile as the door that he pulled that night and pulled me out of my car. With all the, I'm sorry. Yeah. I'm sorry. I thought my life would be easier after the first couple of months, which I forced myself to accept that things has already happened and I cannot change it and I should just move on with my life. I got my car back from the repairing shop and I thought everything was getting better. But I did not realize that was the beginning of another nightmare. Since Darrell totaled my car, even if I sent it to the repair shop, they could not fix it. They was not able to fix it fully. After a car has been badly damaged, it's just impossible for it to work the same way. I was left with no choice but to send my car back to the shop again and again and again. I had to take time from work, and with all the inconvenience and it caused in my life, I also have to pay out of my own pocket for all those repairs because insurance only pays for things once. With all of the financial and mental damage that I have suffered through, I believe, Your Honor, I have the right to ask you to give him the max sentencing if possible. Yes, 14 years old. It sounds so young. But at the night that he pulled a gun at me, does it matter that the person who was holding the gun is 14 years old or 54 years old? He has the power right then and there just to end my life, and I will never be able to talk to my family and do the things that I want to do and I want to achieve in my life. My Honor, please take account into the huge impact that he has made to each of the aspects to my life, and then make your sentencing decision. I would have said something different standing right here today if I have even once received any kind of apology from himself or his family, which I did not. Over the past 18 months, his behavior of cutting off his ankle monitor and running away did not make me feel like he felt remorse. Your Honor, I wish you can take into consideration of what I said today before you make the final decision. Again, thank you so much for letting me speak.
I'm really sorry for what you went through. How much did you lose? Did you count up the funds of what you lost as a result of this?
I believe I have talked to the prosecutor about it.
I believe it was included in the victim impact statement that was sent to probation, Your Honor.
I don't have it. So what was it? Do you remember the total?
Well, the night he robbed my phone, $1,300 in total, and my car, the repair was like $10,000, and with all the subsequent repair that I have to pay out of my pocket, and also the money that he spent off my bank account, I would say something around 25K.
All right, hold on just a second. Do we have that, Anthony? The impact statement?
Your Honor, the items purchased online were in excess of $800.
Did you have to pay those? Hold on.
I
Did you
believe I
have-
was able to retrieve some of them just calling bank, telling them it
Okay,
was
so some of the charges they did not make, you were not held responsible for?
yes, some of them.
Do you
Yes.
remember which ones you were held responsible for and the amount, approximately?
That I really
don't remember?
Yeah, because I was logged off my bank. I wasn't even able to get in to check it because he changed the phone number. The
Okay.
phone number was changed and everything was different.
Okay. Do you remember what your costs were that you had to pay that your insurance did not pay for your car?
I have bills of each of those paid, but
Approximately.
I want to say definitely more than 10K.
That you had to pay out of your own pocket?
Yes, yes.
Okay. And what was the value of your phone again?
1,300. 1,200, 13. It's just iPhone when it first came out. Yeah.
Okay. And was there anything else?
Just my car and my phone. That was the biggest one, and then just all the charges that he went
And the
through.
charges totaled what now, Miss Hassan?
I have $8,000 even on it.
But you didn't pay all the $8,000, but you don't remember what you did have to pay.
Sorry,
Okay.
that was too
All
blurry.
right. So, hold on just a second. And we're just gonna, estimate some of these.
Yeah, but after that, all of the repair I paid.
So I'm in the neighborhood, if I take some of the money off of the one that the charges, are we talking about 16,300 roughly?
Yeah, sure, yes.
All right. Then we'll give you a judgment against him for that amount.
Your Honor.
Yes.
We respectfully request a restitution hearing. I don't remember receiving documentation of all the restitution information you presented here today, as well as there were multiple numbers presented for the same item.
Okay.
I'd like to have a hearing to flesh that out.
Anything else?
Thank you so much.
All right, thank you. Call your next person.
Yes, and just to clarify, there was a spreadsheet breaking down the restitution for the receipts.
You said you did receive or you did not
I
receive?
did not receive, I didn't see any receipts.
There was a spreadsheet that was turned over in Discovery doing a breakdown of the restitution.
But we would need receipts of what items were funded by the bank and what items were funded by the bank.
Good afternoon, early afternoon. My name's
Good morning.
Elena. Good morning. Can Elena
Or you can
D'Onofrio.
bend it towards you.
It's
There you go.
Donofrio. Okay, I also sent restitution because it was, I forget the name of the
You're
probation
Elena?
officer. Yes.
Okay. Very good. What would you like me to know?
It's not that easy to keep this simple, but I really don't have that much energy left to give to this after how it's affected me and people in my community. I have a ton of sympathy for anyone in a situation like this. And I also believe that everybody deserves love and justice. And so I hope, Your Honor, that Mr. Travis is held accountable in a way that is eventually beneficial to him, but also to all of us. Ross, Frankie, and the rest of society. So, like, I'm in agreement with that. That's what's happening, right? But yeah, no, mine was like over $18,000. It's still not final. The cost, like the economic, and
Tell me what happened in order,
Well-
what the costs were for.
my car was smashed, so it was like $13,000 to fix that.
And was there,
It was
did
on
you have
Christmas.
insurance?
It was on Christmas, okay?
Did you have it?
Yes, I did, but it was progressive and it was not all the way. It didn't cover.
Did you just pay your deductible?
No, I had to out of pocket get it fixed and borrow money to do that I owe still. So I'm in debt from school and stuff, and I just got, set back more. But I mean, it's about my personal life. I worked really hard to be where I got to in my life, just for life not to be valued, like we have all said in here. That's all I have to say. I just hope that, with everything considered, it's fair and just for everyone that's involved.
Thank you very much.
Thank you.
Hello, my name is Frankie Collins. The last name is Collins.
Okay.
Before
Frankie or Francis?
my real name is Francis, but I go by Frankie.
Okay, go ahead.
Before I begin, I would just like to say that part of me never thought this day would come. It seems as if this day has been over 1.5 years in the making. There's been a lot of delays and cancellations, and it's been a while, so I'm very happy that we were all able to be here today, but I'm sorry that it's here on these circumstances. The night of December 27th, 2021, I was going to Little Italy because my boyfriend was moving to France, so a bunch of us were gathering at his house for a going away party. I parked my car right outside of his apartment. The area in which I parked it was literally right across from his front door. I could not have been parked any closer, and it's a place that I have gone many, many times, and it's an area that I felt very safe in. I'm a resident of Cleveland. I grew up over on the east side, near Mentor and Willoughby, so I'm from the area, and I go to law school at Case Western. So the area in which I was shot twice was less than a 10-minute walk away from the law school. And the night in question, we were going there for the going away party because he was moving the very next morning, and I never made it inside, and I really wasn't ever given a chance to say goodbye because I had to go to the hospital, and it was during COVID, so we weren't really allowed to have any visitors. And we could have one visitor, so my brother got there first, so I couldn't even see my mom or any of my other family that came to see me to see if I was okay. And that night on the way to the hospital, the police were able to contact my brother first, and all they told him was, your sister has been shot and she's going to this hospital, and he tried to ask them if I was okay, and they said they had no idea. So there was about a 2-hour span where my whole family was awake, just wondering how I was, if I was even alive. I wasn't able to reach them because there were various tests I had to undergo as soon as I got to the emergency room. When the event happened, I heard a very loud noise when I was shot, and I felt pain in my leg, so I knew I was shot there. And I sat down on the curb, and somebody in the area, believe it was an off-duty police officer, he lived in the area, and he heard the noise, and he knew what it was. So he came running around the corner and started applying pressure on my leg almost immediately because I think they were worried about one of the veins being struck. And I was telling him, my stomach hurts really, really bad, and he said it's probably just shock. And I don't know how long I had to wait before the ambulance arrived. It was probably 10 or 15 minutes, and when I got in the ambulance, they finally took off my shirt, and that's when the paramedics told me, you know, you've been shot in your side, right? I didn't know at the time. There was no pressure or anything being applied. It was just bleeding everywhere. The sweater I was wearing was matted with blood. I had on a coat. The whole inside of it was covered with blood as well. I couldn't stand up by myself for at least 2 days. It was very hard to move when I was in the hospital. I had to lay still, otherwise everything hurt. I guess you never realized how many muscles you use to move until you have so much pain in your abdomen. It took about 3 weeks before I was able to stand up straight and walk. I used to like to go running before this, and I wasn't able to run for at least 4 months afterwards without pain in my abdomen. That following semester at law school, I was taking an evening class, and as it was around January, February time, it gets dark outside very early, and I almost never wanted to walk out to my car by myself because I was afraid of something happening again. I mean, the mental toll that this event had on me has been very deep, and it is something I have tried very hard to process and work through, but it is going to take a lot of time. When I was in the hospital, I think I felt as if I was in a very safe place, so I felt very okay then. But the very first night at home, I couldn't sleep. I was terrified somebody or something would come around the corner out of in the dark again. Not even what would happen when they came around the corner. I think it was just the mere fact of the unknown that scared me the most. I could only sleep by locking myself in a closet or in a bathroom, just a room with no windows. And that happened for a very long time. Throughout the entire semester and the following year, there would be various nights that I would be so paranoid of what was in the dark that I would push my bed in front of my bedroom door because I was too afraid to walk into my apartment just to go down the hallway to go to the bathroom or something. I would close all the blinds because I was afraid, I don't even know what, of maybe somebody looking in. There were various nights that I couldn't sleep. Any noise outside would terrify me. I'm actually surprised I didn't give myself a heart attack or a stroke during some of those nights because I was just so petrified and full of fear. And I know it's completely irrational. And I would tell myself that every night when I tried to sleep. But when something like this has happened to you, when you're in a safe place, in an area that you've known your entire life, it hurts. It's a very deep pain. And I just want the court to know that I have been trying, and it's affected me very, very deeply and very greatly. I almost debated dropping out of law school because my grades directly suffered as a result. Every time nighttime came, it was almost as if I couldn't function anymore. I didn't want to walk past a window. I didn't want to turn on lights. There was one time when I came home from work that I thought maybe somebody was in my apartment. That night I was robbed. My apartment keys were also stolen, and they were never returned. And while the landlord had the locks changed, I think it was maybe just the fear of potentially somebody popping up there that scared me. One of my friends had to come over and check the whole apartment for me just to make sure it was all okay. I had nightmares almost every single night for the first 2 to 3 months after the event, and they would happen, I would say, sporadically afterwards. I think my last one was in February, but most of the time it would be me sleeping and somebody would be crawling through a window or maybe opening my bedroom door, and I couldn't move. I was just frozen with fear, and you just watch somebody approach you with a gun, and you don't know what to do. I mean, it's been a lot, and
Did you finish law school?
actually, I'm a 3L, so I still have another year to go. But it was a really rough time last summer because I really wanted to be good in school, and I wanted to do my best, but it was hard to go to class in the evenings, do all my readings on time. I didn't have any energy to look for summer jobs or internships or anything just because I had a lot to process and a lot going on. So I would say it's directly affected my time there. And, this year has been really good. I am working in DC and I'm very happy with what I'm doing, but last year was probably one of the worst years of my life. I was depressed, anxious, paranoid all of the time. And I really tried to not show it and keep going because I was very active in the law school. I am captain of 2 moot court teams there, and involved in various other clubs. And normally I like to play sports with my friends and be social, but obviously there was a time period where I couldn't do all of those things just because of the physical pain. But now, I have been to the area in Little Italy where this happened. It's very interesting to walk by it again because I almost feel like there should be a danger sign or a caution sign there. It's just a very inconspicuous place to walk by it and you know what's happened there. But this has had a huge effect on my life. And I don't really know that I'm finding the right words to convey it to this court. But despite it, I really have tried my best to persevere and keep going and be the best that I can be every single day. And I would just ask this court to take note of it and reflect that. And I think personally, I would appreciate if you could sentence him on the higher end just because of the huge toll it's had on me and the fact that I almost died that night. It's not something that I say out loud all of the time, but you never know what can happen. And I guess in the moment, when I saw the light, I don't know, it made me think of the story a few years ago of the child who was playing with the gun in the park with the orange tip on it. And I don't know anything about guns, so I thought maybe just colors in general meant maybe it was fake. But, I quickly found out it wasn't. But it's been intense, and I really respect you taking the time to listen to me and your appreciation through all of this. So thank you so much.
I thank you, and I'm really sorry you had to go through all this, and thank you for coming in today.
Thank you, Your Honor, And may it please the court, the statement just again submits to this honorable court that the defendant deserves the higher end of the range. The court heard from the multiple victims in this matter, 3 of whom were students at case or are students at case. One victim actually moved out of the state because of this incident and is not present here today. That was the first carjacking victim. So again, because of the impact that this has had on the community, the complete disregard for human life, and the fact that once this court gave this defendant a chance, he threw that chance away and absconded, the state submits that he deserves the higher end of the range. Thank you.
Thank you very much. You can come back up with your client.
Thank you.
And counsel, you can decide the order, whether you want your client to speak first or some of his family or friends, whoever you want to do. It's up to you. Just let me know.
Thank you, Your Honor. Ms. Daniels? Ms. Daniels, Mr. Travis's mother first.
All right, I'm sorry. Then your client, she can remain seated until she gets done, until all the witnesses get done.
Oh.
Okay, so his mother's not speaking, so who else is speaking?
Yeah. Your Honor, Your Honor, can I have a moment?
Sure.
Thank you.
Hello, Your Honor.
Good morning.
Good
State your
morning.
name for the record, please.
Mercedes Crosby, Crosby.
Okay. What would you like me to know?
Okay, I'm Darrell Travis' sister. What I'm saying today is, I understand what he did was wrong, but to say he need the match system and he only 15, he didn't take their life. They still wake up every day and see a daylight. We're not gonna see him until he's like 25 or older than that. Like, y'all have to give him some type of like sympathy other than just giving him life. Like, he didn't kill nobody. We know that what he did was wrong. He robbed, carjacked, he did all that. And I'm sorry for that, what my little brother did. But please, do not give him the match life. Darrell is a good kid. He always helpful. He always nice. He always help us out whenever we need. He always babysit when we need him to watch our siblings, our kids. Darrell is not what y'all think he is. He is a good student. He is a good kid. Please do not take him from us for that long. We understand. But he did not kill nobody. They still get to see the daylight. They still get to go to work. They still get to be with their family. Y'all gonna take him away from us. He's only 15. Please. And again, I'm sorry that happened to y'all. Please do not take him for that long. We understand he's gonna do prison time, but he's only 15. Please remember that. He's not an adult, and y'all charge him as an adult. He's not. He's still a kid at the end of the day. Like I said before, they still send daylight. They still wake up in the morning. They still be able to go get a new job and everything. Please.
All right. Thank you. Anyone else?
Yes, Your Honor, my client would like to address.
All right. Come on, bring it in. All right, Mr. Travis, what would you like me to know?
I would like you to know, like, that I apologize to all the people that I harmed and took from. Like, I didn't, like, it wasn't all planned. Like, I didn't want to do that.
It what now?
Like, it wasn't all planned. Like, I wasn't planning to do that. I wasn't planning to hurt nobody. I wanted them to know that I really apologize, and I apologize to you for not keeping your word and cutting off my ankle monitor. I was just afraid, like, I wouldn't, like, get out and see my family again. I didn't know what was gonna really happen. And then, I just want them to know, like to them it probably seemed like I just went outside today and said I'm gonna go shoot somebody and take their car. It wasn't planned like that. I didn't want it to go like that.
Were you working for somebody? I can't imagine a 14-year-old doing what you did.
No, I was just young and lost. Like, I didn't really have nothing at the time, and like I was angry and lost. I didn't know what to do. I was just walking around doing stuff.
Why were you angry?
Like, I didn't have like nothing for real. Like, I wanted something better for my life. I didn't like. I was tired of not having nothing. I know it sounds wrong. Like, to take it from other people. Yeah, it is wrong. No, I don't know. It's wrong. I just apologize. Like, I didn't realize what I was doing.
Anything else you want me to know?
No, Your Honor.
All right, after consideration of the record, the oral statements made today, looking at the pre-sentence investigation report, the purposes and principles of sentencing under Ohio Revised Code, Section 2929.11, the seriousness and recidivism factors relevant to the offense and offender pursuant to Revised Code Section 2929.12, and the need for deterrence, incapacitation, rehabilitation, and restitution. The court finds that a prison term is consistent with the purposes and principles of sentencing set forth in Section 2929.11 of the Revised Code, and finds that the offender is not amenable to an available community control sanction. Furthermore, the court has considered the factors set forth in 2929.12 and finds that a prison term is commensurate with the seriousness of the defendant's conduct, its impact on the victims, and that is reasonably necessary to deter the offender in order to protect the public from future crimes and would not place a necessary burden on government resources. The thing about a case like this is that there's so much damage done to the people. And even though you may say, or your family may say, well, you know, no one died, but for these victims, they really went through a lot. And even the ones that were not shot, because as you hear, they're scared. I mean, they're looking around the corner, they don't know, because anybody who is affronted with a weapon and threatened with a weapon, that's not something that you forget. You don't walk away the next day and go, oh, that was nothing. No. You're worried about it. You're concerned about it. You have nightmares about it. You see people popping up places where they don't exist, but in your mind, it's tough. So even though you're 14, and trust me, I think about the age. You were 14 when this happened. And that's why in my mind, I just can't imagine that you did this on your own, but maybe you did. But it just seems like at 14, someone had to be directing you to do this. But the number of ones that you did here, because what we have 4, 5, and with one person being shot. And it's a lot. And even though, you know, your family is saying, please, you know, don't send him away for a long time, on these charges, you have 15 years just in gun specs before I even get to the underlying sentencing in this matter. There's 15 years of gun specs. So by the time you serve your gun specs, you're going to be 30. Then the question is, how much more? the parties agreed for 18 to 25. And I personally think that that agreement was a great agreement for you, Mr. Travis, because they could have demanded a lot more or just said, we're not going to put a limit on it. We just want this court to do whatever. But I am going to adhere to what the parties have recommended. Now, what that means for you, Mr. Travis, is, and I haven't told you what number I'm going to give yet, but it means that you cannot apply for judicial release. That means that whatever number I give you, because you agreed with the state to the number, as long as I stay in that range, you cannot apply for judicial release. You must serve every year that I give you. You know, it's a sad commentary when we're dealing with people in adult courts who are 15. I don't like it. I don't like children over here. But you're here, and I've got to do what my job. Yes. So, every victim here is important, and every victim deserves to feel as if they, in some way, is compensated or, in essence, taken into consideration for the penalty that you get. And I can tell each of the 5 victims that on each of their cases, there is a 3-year gun spec, and he will serve those 3 years individually for each victim that was harmed in this case. So let's begin. I'm going to first just talk about the gun specs. In the amended count 1, the defendant is sentenced to 3 years on the firearm specification. That time will run consecutive with the amended count 8 3-year gun specification. That gun specification will run consecutive to the 3-year gun specification in the amended count 15. The time will run consecutive with the gun specification in the amended count 22. That time will run consecutive to the gun specification in the amended count 29. So as to the gun specifications, the law requires that we run those specifications consecutively. So on the gun specifications alone, Mr. Travis, you are sentenced to 15 years in prison. Hold on just a second. As to the underlying offense, aggravated robbery in the amended count 1, the defendant is sentenced to 6 years in prison. As to the Reagan-Tokes is implicated in this particular count, and therefore the defendant is also sentenced to a maximum indefinite term on the amended count 1 in the amount of 3 extra years. Mr. Travis, there is a rebuttable presumption of release at the end of the minimum term that I've indicated, which is 6 years on the underlying offense in the amended count 1. The Department of Rehabilitation and Correction is authorized to continue the incarceration to the end of the maximum term, as I said, the 3 extra years, so an additional. So on count 1, with the 3-year gun spec, you're looking at a minimum term of 9 years, a maximum term of 12 years. If the presumption is rebutted at an administrative hearing, the DRC can continue your incarceration for the entire maximum term. The Department of Rehabilitation Correction is to set rules and criteria for it to rebut the presumption of release as to specific determination as to the defendant's conduct pursuant to statute. At the end of the maximum term, the defendant must be released. What that means to you, Mr. Travis, is that your conduct in prison will directly affect how long you will be there regarding the extra 3 years or the indefinite sentence pursuant to Reagan-Tokes. As to the amended count 8, the defendant is sentenced to 6 years in prison on the underlying offense. As to the amended count 15, the defendant is sentenced to 6 years in prison. As to the amended count 22, the defendant is sentenced to 6 years in prison. As to the amended count 29, the defendant is sentenced to 6 years in prison. As to the amended count 34, the defendant is sentenced to 2 years in prison. As to count 38, the defendant is sentenced to 1 year in prison. As to count 40, the defendant is sentenced to 1 year in prison. As I indicated earlier, the firearm specifications all run consecutive for a total of firearms of 15 years. The underlying offenses will run concurrent for a total time of 21 years in prison. Upon your release from prison, the State of Ohio Adult Parole Authority, and not this court, shall have a mandatory minimum of 2 years up to a maximum of 5 years under what is called post-release control. If you fail to meet the terms and conditions of any post-release control supervision imposed upon you, then the Adult Parole Authority can modify and/or extend your supervision and make it more restrictive. They can incarcerate you for up to half of the original sentence imposed by this court. They can charge you with a new offense called escape, another felony where you could face additional prison time. And if you commit a new crime while in post-release control, you can receive the maximum penalty under the law for the new crime committed, a prison term of the greater of 1 year or the time remaining on post-release control, in addition to any time that you receive for the new felony. The prison term for the post-release control must be served consecutively to any prison term you receive on the new felony. And what that means to you, Mr. Travis, is once you get out of prison and while you are still on post-release control, if you commit another crime and you are sent to prison for that crime will run consecutive to any time that you have left on post-release control. Unless the defendant is serving a time that cannot be reduced, and in this instance, as I indicated to you, your time cannot be reduced in this, so I won't even bother reading that section even further. I am going to assess court costs against you. However, those court costs will be paid through court community work service within the confines of the prison in lieu of any cash payments. That means that you won't have to pay any cash payments at that time. However, you will have to do work in the prison to work off the court costs in this matter. Now let's talk briefly about restitution. The defense has indicated that they did not get anything regarding restitution in this matter.
Your Honor, there were 280 documents. There are no documents entitled summary of restitution or anything like that. So if there is a spreadsheet, I did not see a spreadsheet, as well as, Your Honor, when you're talking about a restitution upwards of $10,000, $20,000, we would want documentation as well. The victim, because I don't want to re-victimize anyone else, but we would want to verify the numbers, right? So that way there's not a double recovery on the restitution. So we would want to communicate with the bank, we would want to communicate with, see receipts of repairs that were made. So we just want to verify that whatever restitution amount is the actual number, the actual economic loss to the victim. So that's why we requested
Do
a
you
restitution.
agree that he used her credit card and charged up a bunch of stuff?
No, Your Honor.
You don't?
That's not the agreement.
Okay.
As it relates to the restitution, we would want to see the
Okay.
documentation.
On behalf of the state of Ohio?
Thank you, Your Honor. May it please the court, there was a spreadsheet that was turned over in discovery labeled expenses TIO. Additionally, I believe the probation officer that did the pre-sentence investigation report did reach out to the victims regarding restitution in this matter. I have spoken with the victims just now, and they would like to waive restitution in this
Okay.
matter.
All right.
Thank
Thank
you.
you very much. All right, Mr. Travis, you have the right to appeal this sentence within 30 days of the entry of the court sentencing decision, and you have the right to have a notice of appeal timely filed on your behalf. If you're unable to pay the cost of an appeal, you have the right to an appeal without payment. If you're unable to afford counsel for an appeal, counsel will be appointed for you without cost. If you're unable to pay the cost of documents necessary to effect an appeal, those documents will be provided to you without cost. Mr. Travis, do you understand everything that I've said?
Yes, Your Honor.
Do you have any questions you need to ask me at this time?
No, Your Honor.
All right. Defendant is ordered to the custody of the sheriff for transfer to the appropriate correctional facility. Credit will be given for all time served in case number 674056. Anything further on behalf of the state of Ohio?
No, Your Honor.
Anything further on behalf of the defendant?
Yes, Your Honor, if you would allow me. Your Honor, Mr. Travis would object to the imposition of Reagan totes in this matter, so it's noted for the record. Your Honor, we would also ask at this time that appellate counsel be appointed. It was stated to me the desire to file an appeal.
Okay.
And Your Honor, as it relates to the imposition of costs and fees, when the court orders costs and fees for the prison, it will make it difficult for Mr. Travis to have money on his books so that he can communicate with his family and so that he can still have a connection with the outside world and purchase regular toiletries and things to clean his body. And so we would ask that those costs and fees be waived so that way Mr. Travis will at least have access to his family and have access to personal necessities while
He will still have access. What I did, I made it where it has to be done by court community work service within the confines of the prison. They will not, that does not affect his books. That's why I do it that way. So he just has to work it off. It says that there is no cash payments that are necessary to be received, okay?
Thank you, Your Honor.
All right,
And
anything else?
The last request is if Mr. Travis could also be credited for his juvenile time when he was incarcerated.
I don't have any problem with that. It's up to the people that count the numbers. I don't have a problem with it because it was involving this case, and I know that he was bound over. I don't know if they will get it before he was bound over or just after, even though he was still in juvenile center. So on behalf of the state of Ohio, do you know?
Your Honor, I believe he's entitled to it, and I have a number of 525 days.
Got it. So 525 days, and we will double check that as well.
Okay. Thank you, Your Honor.
But he gets credit for all the time that he served.
Thank you, Your Honor.
All right. Thank you very much. And Mr. Travis, use this time to get educated, to get your college degree, and learn a trade so that when you come out, you can be a productive member of society. You know, when you come out, there's going to be a lot of odds against you, because you're going to come out after being in for a long time. But when you come out, while you're in, get smarter, get smarter, get your high school diploma, get your college degree, and learn some trades so that when you come out, you hit the ground running. Thank you very much and good luck to you.
Thank you, Your Honor.
Thank you, Your Honor.
We love you, Darrell. We love you.
Was Chris up there?
He was in Kathy's, but he's still out there.
He's in the hallway.
I don't know if he's done in Kathy's, but I can check.
That's what, yeah, that's what, it's weird.
Good afternoon now.
Yes. Hey, don't forget, guys, that live streaming, I know that, that person really don't, you can tell them, don't keep showing it. Don't go to live streams and all that.
Thank you, Judge.
You're very welcome. Welcome to my court.
Thank you. First time. Mine too.